Good afternoon, good evening already, and it's really a challenge to give a presentation at this late hour of the day. But I'll try to maybe be a little bit even shorter than I intended to. The issue I want to address today is I call it legal or illegal denial of microtrauma in mental injuries, and I would better name it bioethics of the problem of denial microtrauma in mental injuries. Now, the presentation is going to focus on one legal area, which is work accidents, but it implies actually to a much wider field, actually to the tort law, to disabilities, but I'll come to this later. So according to worker compensation statutory rules, accidents attributed to work may occur in one of three ways. A clear physical event occurring during work unexpectedly and derived in a clear and visible result. The classic case is a physical injury caused by a sudden event. The second group is a series of minor injuries occurring over a long period, where each of such injuries is in fact a mini accident which cannot be attributed to a particular point on the time and location scale, as water drops which in a big rock and are accumulated during the general injury the worker may suffer from. This is a concept of the microtrauma. The example to this is a tractor operator or a heavy truck driver who are driving on a rocky rocky ways for a very long time, and the little shocks accumulate in the spine, and then they suffer from spinal injury. This is recognized by the Israeli law as microtrauma. Now, the third one is of worker compensation statutory rules that can compensate workers for work accidents, and this is by the National Social Security System. Everybody in the Western countries pays a certain amount to Social Security for such occasions when people are damaged during the work and cannot work anymore. So instead of throwing them on the family and others, they pay like an insurance to the Social Security, and the Social Security will compensate them if they become disabled due to work accident. So the third group of work accidents is what is called constitutional diseases, like which are diseases which cannot be recognized as or seen, like orthopedic injuries, and these injuries are referred to constitutional injuries, like myocardial infarct, like diabetes, and of course mental diseases, which are not perceivable on the outside. So a constitutional disease, when I talk about a mental injury, is recognized by the law as a causal relationship to work and is entitled to compensation. However, it should be caused by a sudden and major event. Now, when it is a continuous stress, this is not recognized by the courts. Now, the So in summary, microtrauma is recognized by the Israeli legal system as a cause for worker compensation for injuries contracted during or due to work. But does the Israeli legal system recognize mental injuries and mental disabilities as a cause for workers' compensation for mental injuries contracted during or due to work? Now, the case is a case that came to the Supreme Court in Israel back in the late 90s. And the case is of a person that had been with deep troubles with the income tax authorities, and they went into investigation for a long time, and he felt that he was chased by the income tax authorities, and he was in a serious threat for closing down his business. And he went into distress over a long time, brought him into a deep major depression, and he tried twice suicide. Now, after a while, he came to the Social Security and asked for compensation for workers' accident, and the Supreme Court, Judge Strasberg Cohen, who was at that time in the Supreme Court, said that micro trauma in mental health is not recognized by the court. So, and she said that the legislator set the rule of the occurrence of accident, and indeed the social legislation is aimed to compensate the disabled. However, it does not cover everybody, but only those who meet the legal criteria. And she thought that microtrauma in mental health does not meet legal criteria. So I will not go into details, but the question that I'm asking is, how can Justice Strasberg Cohen be so firm in setting medical statements when even clinicians are debating as for the etiology of mental diseases? And this is a fact. Psychiatry has advanced so much since the mid-20th century until today in the psychopharmacology and in many other areas, but the etiology of the diseases, and the question is why a person develops depression and another person does not develop depression when they overcome or when they face the same stressogenic events, or why does one person develop PTSD and another one does not develop PTSD, and why one person develops psychosis and another one does not develop psychosis, and when does it start, and when does a schizophrenia start? We have had an excellent opening presentation this morning about it, the physiology of the brain. We know everything about the anatomy. We know everything where about the conductivity, the electrical conductivity, but the thoughts and the feelings and the ideas, this is something that we still don't know. And psychiatry cannot tell for sure. So how can a judge tell for sure that after a long period of stress, a person that developed some mental disorder and there is no causality to the stress because it was over a long time? And then did Justice Strasberg Cohen take into account that in social statutes any doubt is interpreted to the favor of the disabled? This is a rule, not only in the Israeli legal system, that in social rules you have to be generous to the disabled. Now, if there is we are not talking about a criminal case that you have to prove over any doubt that the person had committed the criminal offense. But when we are talking about the civil case, we are talking about the probabilities. Now, we know that a person, before the stress began, functioned normally and perfectly, and after a certain period of stress, he's depressed, he's maybe even has some false ideas, maybe the depressive state is also glitching into psychotic ideas. But how can you judge, how can you say that this has no relationship to the stress? Now, I think that this question is actually connecting with some other presentations that we have heard today about the rights of mental patients, about the human rights organization should examine this issue very seriously, because the courts are very cynical about the mental diseases. Yes, mental diseases are not seen with the eyes, but they are there. So how can you say that these people cannot be granted their social rights? And if we heard Sagit more today about nothing about us without us, then the courts actually are discussing their cases without trying to understand the rights of these patients and the feelings of these patients. So to conclude, in the message I want to, and like I said in the beginning, this implies not only to compensation of workers, it implies to the entire area of tort law. If a patient, if a person is injured and his suffering is actually not from physical injury but from mental injury, if we have to set the disabilities. Now, the being cynical and not recognizing mental injuries is somewhat ignoring the fact that the mental diseases are there. So this is actually a criticism which I present today on the decision of the Supreme Court, and I hope that with the years, and better sooner than later, this Supreme Court precedent will change. Thank you very much.